joining us on the Coors Light hotline. It's John's favorite drink, and it's our favorite hotline. Bill Stradley, a criminal defense expert, attorney, and former assistant district attorney for Harris County, joins us right now. Bill, thank you for your time this morning.
Good morning. Glad to be here. Thank you.
So yesterday, Aaron Hernandez arrested for murder in the first degree, which carries a life without parole, I guess, sentence in Massachusetts. But what's the next step? We heard the charges yesterday. What's the next step in this case?
Well, at some point, I talked to a friend of mine in Boston yesterday, and he said they do have a grand jury system in Boston. So the case will have to be blessed by a group of independent citizens for them to determine whether they think the case passes the smell test, basically. Mm-hmm. Based on what I heard during the hearing, I think they've got a lot to work with, to say the least. Mm-hmm. So after he's indicted, he'll be taken to presumably a different court, which will be the Superior Court in Boston. And his case will be brought to court on a fairly regular basis, about every month or two, until such time as it's set for trial and it goes to trial. But the lawyers will have other opportunities to request bail or to try to present evidence that the defendant, Mr. Hernandez, is not a flight risk and is not a danger to the community.
All right, you mentioned yesterday. I want to go back to yesterday. To me, it was riveting stuff, as I'm sure it particularly was for people in your industry. But it was also, it raised some questions for the novices like me. Why, and this is just your perspective, I understand you're not involved, but, why was he not given the right, in your opinion, to turn himself in? Why was the prosecution so thorough and laying? It seemed a little bit of a surprise to me. Usually they say, we think this guy killed somebody, and I know I'm oversimplifying that, but you know what I mean? He wasn't giving, almost like as if it was a trial to the judge as to why he wanted these charges brought.
Well, I know it seems like grandstanding, but I think there was a legitimate purpose for that 20-minute laying out of the evidence. As you know, or as the judge said at the conclusion of the hearing, usually they want to give a bond to just about everybody. That's the presumption, unless it's a first-degree murder case, and then the judge can hear evidence as to whether or not the case is strong, number one, and number two, whether or not the person is likely to be a continuous danger to the community. And so they really needed to lay out a strong case in that regard if they wanted to hold him at no bond, and they certainly did. I mean, I'm telling you, I've seen a lot of cases.
Well, stop right there. You've mentioned that twice now. Why do you think it was so strong?
Well, they've got him on video basically all the way there and all the way home. Number one, that's unusual. They've got cell phone records indicating that the decedent was texting his sister, saying, "I'm with Mr. NFL just in case, somebody needs to know later." Mm-hmm. That's pretty strong. You've got Hernandez walking through his house, and he's on his own surveillance cameras, walking through the house with the gun, acting paranoid. And clearly there are two other so-called Confederates involved, and I'm sure they have something to say. It was interesting that the district attorney did not mention what they had to offer, so clearly he didn't lay everything out, although he laid what would seem to be most of it out.
Mm-hmm. Bill Stradley, a criminal defense attorney and former assistant DA for Harris County, joins us here on the Coors Light Hotline in the Loop, Sports Radio 610. When it comes to this case, is it common, uncommon? Is it positive? When I look at this, and I'll take a step back and just give you my 2 cents on it, Bill, and not necessarily this case, but to me, if you've got good attorneys, if you've got the money, and it looks like, Aaron Hernandez has the money, usually good lawyering beats bad lawyering, and I don't mean to knock, because you've been on both sides of this. You were a DA, but usually, those are the guys, even if they're great, whether it's you or Rusty Hardin, they're the ones cutting their teeth, so to speak, in the law profession. Now that you're on the other side of it, you're defending guys, so now that you become the expert, so to speak, and it's like the better lawyering is going to be, especially with money, on the side of the defense here. So they don't have a weapon, it doesn't seem like, and unless one of these guys has rolled, one of the two guys, and we now know the name of one of them, but unless one of those guys has rolled, is there going to be enough? Because the defense is claiming this is all circumstantial, and we as spectators watched the OJ thing and thought, boy, oh boy, they got him nailed to death. And while they won in a civil lawsuit, they didn't win criminally.
Well, I heard the lawyers say that it was a circumstantial case and it was a weak case, but from my perspective, that's like saying these aren't the droids that you're looking for. I mean, it seemed really strong to me, and like I said, I've seen a lot of these cases, and like what you mentioned earlier, access to good lawyers is obviously helpful. Clearly, it is, but you still have to deal with the facts. Now, it may be that one of the Confederates has already offered their support and rolling, so to speak, on Mr. Hernandez. I'd be surprised if they weren't trying to do that, because they're also looking at first-degree murder, which carries the punishment range of life. That's it. So I'm sure they're going to want to try to work out some kind of deal. And like I said, the assistant district attorney didn't mention it.
Right.
But they've got to have something from those guys. It would just be, I'd be shocked if they're not already on board with the prosecution.
Based on what you have seen thus far, how do you think, lay it out for us and our listeners, how do you think it plays out from here? With particular, I'm curious about, in particular, I'm curious about, it held without bond is not a permanent thing necessarily. How you think that will play out, and the case itself, specifically admissibility of some of his past problems, etc.
Well, that's an interesting issue. We call that extraneous offenses in this business, and lots of times a case can turn on whether or not a person has a history of doing the same kind of thing. So if I've heard that there was an incident where he shot another one of his friends,
right, and then they found that .22 and not the gun that was supposedly used here. So that's why I was curious.
Right. Well, that is likely to come into evidence during the trial on this case, and that's obviously going to be very damaging. I mean, how often do you have a guy that shoots two people in the span of 6 months? They're going to try to argue that that's admissible under 404B of the Rules of Evidence as relevant testimony on the issue of whether or not he is a violent person, and to counter any defenses such as, well, it was a mistake. Oh, really? Well, how about the fact that you shot this other guy 6 months before?
Right.
You're mistake prone.
Yeah.
Right.
You're just a bumbling, stumbling guy. What about the, as I mentioned, the held without bond, and is that going to be permanent?
You know, they always will have an opportunity to go back to the judge and say, look, we have a new argument as to why we think he ought to be out on bond. The best argument that the lawyer had to present was he's clearly been on notice that something was going to happen for the last, 10 days?
Yeah.
Right.
And he hadn't run off yet. So why do you think he's going to run off now? So that's a fairly good argument, but like I said, what the prosecution is relying on and what the magistrate relied on yesterday was this act, if true, is so bad, and he's clearly a danger to the community, so we can't let him out. Besides which, there's a presumption against bond with a first-degree murder charge. So, but if he's indicted, his case will be presented to a different judge, and there will be another opportunity to ask for a bond then, and clearly the defense will have plenty of time to put together a more compelling argument. How
important is it that they now have the one Confederate, as you put it, Carlos Ortiz, and there's another one presumably out there that they will find. How important is what they say, given that there is no murder weapon, so to speak, found?
Well, there have been cases obviously made many times without a murder weapon, and this is as close to actually having a murder weapon as you can be, given the fact that he's walking through the house 3 minutes later with a gun that is like the one that was used to kill this guy.
Why didn't they find that gun then, do you think?
Well, I'm sure he threw it out somewhere. Well, that's a big assumption.
Right.
I think it's pretty safe.
Objection, Your Honor.
I think it's pretty safe.
Right.
The attorney's leading the witnesses. No, Bill Stradley, criminal defense attorney right now, former assistant DA for Harris County, joins us on the Coors Light hotline. I would ask you this with regard to and I don't know how important this is in this case and in the evidence that you feel is pretty strong, and obviously the prosecution did as well, but some of it, I'm assuming, is alleged to have come from his girlfriend / now apparently fiance, and that all becomes, I guess, gagged if they marry, because then she can't speak against her husband. If he's granted bail in some form or fashion, is that a reason for them to try to keep him from getting bail, that they don't want the information that I know that's behind the scenes maybe what they want. Can they do it legally?
I don't really think that's going to be a legitimate reason for them to want to keep him out, in jail. He's had plenty of opportunity to try to keep her quiet in the last 10 days, and I don't think any other efforts in that regard are going to make any difference. I think they want to keep him there because they feel he's such a danger, given the fact that this appears to be so brazen, and the prior shooting 6 months before. I mean, it's just dangerous per se, as we say.
All right, we have about a minute left here in this segment, but I'm curious. Now put on your criminal defense hat, and you are Aaron Hernandez's representation. What do you do?
Well, you talk to those. I use the word Confederates because that's what they used at the hearing, and I think it was in My Cousin Vinny, so I thought it was interesting.
It's kind of cool, actually.
Yeah. And but obviously I'd be interested in what they have to say. If there's any kind of argument for self-defense, that would be the most obvious, road to run down. And whether or not the other two guys may have been involved. I mean, you can say, well, my client had nothing to do with it.
Right.
That's not going to get you very far, based on what I saw yesterday.
Wow.
And juries aren't stupid.
Sure.
So,
Bill Stradley, criminal defense attorney and former DA for Harris County. Bill, thank you so much for your time this morning.
Thank you. I enjoyed it. Appreciate it.
All right, thanks.
All right. Bye.